it's very hot and sunny here.
Awesome.
Unusually today, it's very warm in Manchester. I've just sent you a request so that I can share my. Oh, I can do it now. That's okay. Brilliant.
Chris,
Yeah,
can you hear me?
I can hear you. Can you hear me? Okay.
Uh-huh. Okay,
There we go.
can we begin?
Yeah, of course. Yeah. Shall I get started right now?
Yes, of course.
Brilliant.
Now, today, our webinar with Mr. Chris Sykes, introduction to contract law. Okay. Can you begin, Chris?
I think there's somebody still needs to turn the microphone off.
Қандай отыратыны? Chris өшіріп қоймадың? Өз. Оныкі. Bizdenki.
Oh, there you go. It's gone quiet now. Brilliant. Okay, well, I'll get started then.
Begin.
Oh, no, I can still hear someone talking. There we go.
Yes, of course.
Okay, I'll get started then. Okay, very nice to meet you virtually, everybody, and thanks very much to Dildora and the Tashkent State University of Law for inviting me to speak to you briefly today. So my name is Chris Sykes. I'm a senior lecturer and program leader at Manchester Metropolitan University. I'm a lawyer. I'm a qualified lawyer in the UK. I'm a solicitor of England and Wales. I used to work in the area of criminal practice, but more recently I was involved in the areas of legal technology, and I teach a variety of subjects across various institutions, including contract law, which I'm going to talk to you about today. Probably the most important thing I can give you today is my email. It's there on the slide, christopher.sykes@mmu.ac.uk. So if you've got any questions about what we're covering today, then please feel free to send me an email. Also, at the end, I'll give you some time to ask any questions. You can obviously put your microphone on, or you can message me in the chat. Okay, so the reason I've chosen contract law is because I was thinking of an area of common law, of an area of English law, which you might already be a little bit familiar. Contract law is probably the biggest export in terms of law from my jurisdiction. English contract law is used to govern contracts all over the world. And countries such as Hong Kong, Australia, New Zealand, Canada still very much use the sort of English common law in terms of contract law. So I'm going to go through. It's a very complicated subject, of course, but I'm going to go through pretty quickly and just look at the basics. I am going to refer to some case law. Of course, I'm from a common law jurisdiction, so it tends to be case precedent that dictates the law, not legislation. So you'll see those references in the slides, but don't worry about it too much unless you really want to investigate further. Like I say, you've got my email there, so you can, contact me if you want to. Hopefully you understand my English. I do have an accent from Manchester. If you don't understand something again, you can put a message in the chat or just ask me to repeat myself. That's not a problem. Not it maybe it's not your English, it's my English that's the issue. So there we go. You've got my email, and we're going to just have a chat about about contract law. Of course, contract law is a very important area of English law. Let's get going. Okay, so some of these things may be similar to your jurisdictions, but I'm going to go through the basics right from the start. So we know how do we define a contract? Well, a contract may be defined as an agreement giving rise to obligations which are enforced or recognized by law. So not just an agreement between parties, but an informal agreement between friends or something like that. An agreement that is recognized and enforceable under the law. The law doesn't impose obligations, of course. These are things that we agree to do. So contract law is not about obligations that exist in law. It's about obligations that we've undertaken. So I undertake or agree to pay somebody £20, and in exchange they agree to provide me with a product worth £20. That's the the first thing to say. That's what we're talking about in terms of a contract. Now, from the court's point of view, whether or not there's an agreement, whether or not a contract exists, is assessed objectively. So a court will look at the circumstances, will look at what was agreed, will look at what was written, and determine whether or not a contract exists. So as you can see there, and this is from a fairly recent Supreme Court case, whether there's a binding contract on the parties depends not on their state of mind, but what was communicated by them, what was what were their words or conduct. So whether a contract exists is considered by the court from an objective point of view. Now there are three sort of main requirements for the formation of a contract. So there's a Oh, can you turn your microphones off? It's quite hard to not get distracted. If you turn your microphones off, that'll be great. Brilliant, thank you. So there are three elements here of formation of a contract. There's a requirement for an offer and acceptance. There's a requirement for something we call consideration, which we'll look at later, and you need an intention to create legal relations. So we need to intend. It can't be an agreement between me and my child, or me and a friend that somebody will do something. It has to be an intention to create legal relations. We'll look at these things in more detail shortly. The main thing I'm going to focus on today is this idea of offer. I'm offering to sell you something, and the other side accepts by paying that amount of money. First of all, let's have a look at agreement, the agreement between the two parties. Offer and acceptance. Seems pretty easy, doesn't it? It seems like a fairly straightforward transaction, and often it is, of course. I'm offering to sell you something, I'm offering to do something, and you accept that offer. The agreement must comprise the offer, and it must comprise the acceptance. We must have offer and we must have acceptance. So what's an offer, first of all? Well, it's a statement of a willingness to contract on specific terms. So I offer to sell you my car. It's got to be within it. There has to be a willingness to form a contract. Can't be what's called an invitation to treat. So an invitation to treat is I say to you, for example, oh, do you want to, do you want to buy my car off me? There's not enough detail there. It would have to be, do you want to buy my car off me for £500? Have to be more specific. Think about this in more detail. So, an advert is normally an invitation to treat. It's not an offer. But and of course, it's not an offer. An advertisement says, you can buy this item for £20. That tends to be just an invitation to treat. I'll give you an example of that shortly. So in one case, actually, or in some cases where you've got very specific offer in in an advert, it might be considered to be an offer. So this is a famous case, Carlyle and Carbolic Smokeball Company. So there was an offer of a £100 reward if you still got ill having used. I mean, this is This is a case from over 100 years ago. £100 reward if you still got influenza, if you still got ill using this product. And this determined that, in fact, you can offer to the world in an advert. You can demonstrate your intention by placing money in a bank, which was the case. In this case, the advert was clear, and you could accept that offer by performance. In this case, by buying and using the smoke ball. So an advert can be an offer, but normally an advert is just an invitation to treat. Here's an example of an invitation to treat. Now, if I go into a shop here in the UK, and let's say I go into an electronics hardware shop, and there's a huge flat screen TV, and it's been wrongly labelled. So rather than £500, it's been labelled £50. So the person in the shop has put the wrong label on that item. Now, I can't go. Oh, can you turn your microphone off, please? Thank you. I can't go into the shop and demand that that's sold to me for £50. I can't go in and say, well, you offered it, and I'm buying it. So there's a contract. In a shop, the price is an invitation to treat, and the offer is when I take that item to the till, to the checkout, and offer to pay for it. And the acceptance is when they take the money off me. Okay. So let me go through that. Let me just explain that again. So in a shop, the price of the things in a shop is an invitation to treat. It's an offer for me to make an offer. So I take that item, I go to the till, and that's where I offer to pay for it. And the shop owner or the shopkeeper, they can accept or not. So in a shop, display of goods is an invitation to treat. Normally, adverts are an invitation to treat as well. And there's a case here of Fisher and Bell, which shows that sometimes the law is not always clear. So in the case of Fisher and Bell, it was illegal to offer flick knives, for sale. And the shop was offering flick knives for sale in its window, but because that's an invitation to treat, they hadn't broken the law. We also have to distinguish an offer or invitation to treat from like a proper offer or discussions or supply of information. So look at this case of Harvey and Facey. In that case, Harvey says, Telegraph will communicate the lowest cash price for the bumper hole pen, selling a pen. And Facey says the lowest cash price is £900. And Harvey says, we agree. Facey then refuses to sell. It was held there was no binding there's no binding agreement. Mr. Facey has just said the lowest cash price is £900. It's an invitation to treat. It's not an offer. Be certainty of the offer as well. So there can't be sort of undefined rules. Contract law is all about commercial agreements. Contract law is all about certainty for businesses. That's how contract law has evolved over time. It's got to be certainty. Think about acceptance now. So we've got offer. What about acceptance? So acceptance is the expression of assent to the terms of the offer. It must be absolute, must correspond to the terms of the offer, and must be communicated to the offerer. Okay? Now, it may be that rather than acceptance, it's an implied rejection. Okay, so look at the case of Hyde and Wrench, that first one there. We've got Mr. Wrench offering to sell a farm for £1,000. Hyde replies offering £950, which W rejects. So then Hyde writes again, agreeing to pay £1,000, but Mr. Wrench has changed his mind. And it was held there was no agreement because the counter offer contains an implied rejection of the original offer. On a thing called the Battle of the Forms. This is where things get more complicated because there's an offer, then there's an acceptance, and then there's an offer and acceptance, and the forms are going backwards and forwards. I won't into the details of it, but in Butler and Machine Tool Co., we've got a battle of the forms there. How is communication accepted? Well, it's got to be communicated by an individual, by an authorized individual. It can't just be anybody who works in the company. And generally, the contract is formed when it's brought to the attention of the offerer. Contract can't exist before the offerer is informed. That requirement, is not required where you've got a unilateral contract, which I mentioned with the advert before, Carlisle and Carbolic Smoke Ball Company. And further, silence, so just staying quiet, is not acceptance. Let's look at the case of Felthouse and Bindley. So the uncle negotiates to buy the nephew's horse. The uncle writes, if I hear no more about him, I'll consider the horse mine at £30, 15 shillings. The nephew didn't reply. There's no contract because silence isn't sufficient to demonstrate acceptance. We need an offer. It has to be clear, objectively, and we need acceptance. That also has to be clear. Unless we're talking about a unilateral contract, as per Carlisle Carbolic Smoke Company. Contracts can be terminated sorry, not talking about termination of contracts. An offer can be terminated in a variety of ways. So we've already talked about, rejection. Will you buy my computer for £500? No. Lapse of time, because an offer can't stay open for forever. The offerer revokes the offer. So I say, right, I'm not offering this anymore. Or it's subject to a condition which fails, or it's affected by the death of one of the parties. So if the offerer dies, or the potential acceptor dies, then the offer is terminated. We've already mentioned the case of Hyde and Wrench, where we've got a counter offer which effectively forms rejection. Lapse of the offer. So it might be that the offer has no time. In the case of Ramsgate Victoria Hotel, we have the defendant applying for shares. It was accepted by the claimant 6 months later, but the defendant refused to go through with the purchase because 6 months had elapsed. Offer can be revoked at any time before acceptance. Of course, once there's acceptance, is a contract. We won't worry too much about the revocation of an offer. Is it possible to revoke a unilateral offer? So, an advert. Case law is varied on that, but I think the modern position is normally no. And of course, as I've already mentioned, the death of the offerer normally ends the offer. Okay, that's the first. We've gone through it very quickly, but the key thing is that you understand that we needed an offer and we needed acceptance. The important thing is to distinguish between what's an invitation to treat, as in an invitation to put in an offer, and an offer itself. But once we've got an offer and acceptance, then we're halfway to there being a contract. And in many jurisdictions, that's probably all we need. But in common law jurisdictions, we tend to need consideration, which is the kind of the price of the promise. And this is a fairly complex and sometimes difficult area of law for those who aren't familiar with common law. There's even proposals to remove the need for consideration in various common law jurisdictions, including England and Wales. So this is I suppose the third, offer acceptance. This is the third vital element of the contract. It's the thing that's given in return for receiving the contract subject matter. Some people call it the price of the promise. Got a couple of definitions there from Curry and Misa. The definition is a valuable consideration in the sense of the law may consist of some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. And there's another definition there of consideration under Thomas and Thomas. Pollock says in the Principles of Contract, consideration is an act of forbearance of one party. But I like the simple one from Dunlop and Selfridge, the price for which the promise of the other is bought. Okay. So the modern approach, as per Combe and Combe at the bottom, promises are unenforceable unless supported by consideration. So you can't have a contract effectively for doing something for free. So let's say I want to sell you my phone. I can sell you my phone. I can enter into a contract to sell you my phone for 1 penny, or 1 cent, or €1, or $1. It doesn't matter. But I can't enter into a contract to sell it to you for nothing. That's not a contract. So let's think about that in a bit more detail. It must be consideration must be legally sufficient, something of value in the eyes of the law. Okay, so it's something that is determined to have value by the court. It can either be a legal benefit to the promisor or legal detriment to the promisee. In some cases, it is a bit difficult. Doesn't need to be economically adequate. I can sell you my house for $1. So it doesn't, and this is where it gets a bit complicated. It doesn't need to sufficient. It must be. Let me rephrase it. It must be sufficient, but it doesn't need to be adequate. So we've got various case law there. Chappell and Nestle, the chocolate company, a sweet wrapper was seen as sufficient consideration for some kind of reward, some kind of competition. Borrowing something in Bainbridge, in Thomas and Thomas, £1 per year rent was considered sufficient consideration. Oops, lost the end of my thing there. Sorry. There we go. Let's come back. So you only have there's only a requirement to have a consideration can be, and there's lots of case law on what consideration can be, but there has to be some form of consideration. So you can't just, you can't just have a contract where there's nothing going from one side to the other. So another example, if I, if I act as a consultant and somebody employs me as a consultant, and I say, actually, I'll just do this for free, and we enter into a contract. There's no contract there because there's been no exchange. Normally, there's no problem consideration. Normally, there's no at all because no exchanging hands. One side, one side is, the side. So that in the summary is consideration. So what have we looked at today? Okay. First of all, you offer. You need some form. It has to be clear. Secondly, you need acceptance. It has to be communicated in the manner which is expected, in a reasonable manner, and made in order that the offerer is made aware that the contract has been accepted. Consideration. So that has to be, what was the price of the promise, and then we have a contract. Now, there's a few other things. We mentioned we need intention to create legal relations, but it can't just be some kind of joke. The parties to the contract must be grown-ups. They must be adults of sound mind, so not under some kind of mental disorder. But if we have all those things, we have a contract, common law. So I'm conscious I went through quite a lot of case law there. Those cases you can look up and see what they're about. And as I say, if you've got any, you can follow with me on the email. Okay. I thought I had a slide at the end that said any questions, but I can just ask you: has anybody got any questions about either contract law or English law in general? Put them in the chat if you would prefer.
Now, guys, do you have any questions for Mr. Chris about the contract law?
There's a lot that I've covered in a very short period, but the main thing to note, I'm pretty sure that contract law in your jurisdiction is fairly similar, but the big difference is probably the consideration element. It's what I'm more familiar with, for example, the Spanish jurisdiction. Oh, you're very welcome. Well, if anyone's, I'm sure this isn't a problem, of course, Dildora. It's entirely up to you. You can circulate my contact details, and and the slides. If anyone has any,
of course,
questions about what we've covered today, then they can reach out to me directly.
Thank you for that insight, Chris. It was a
My
very
pleasure.
informative point. And just to remind everyone, do you have any questions? Question and answer session we have now.
Don't worry. Any questions, you can just email me after this.
Yes.
Don't if you're shy, don't worry about it. Nice to meet you all virtually. And nice to see you again, Dildora.
Thank you so much.
Thank you, sir.
Thank you so much, Chris, for
You're
such
very
an
welcome. I hope you all
insightful
have
and
a
engaging presentation. We truly, I think, appreciate your time and expertise, and thank you for to our audience also for your active participation and thoughtful questions. Uh, I hope our collaboration will continue in the future. Yes,
yeah,
Chris.
yes, definitely. Whatever you need from me. Okay, all the best, everybody.
Thank you so much.